We provide the answers and a better understanding of the world around you. Therapy Came Alive. Well, speaking of brain power, we had the unfortunate case of Saturday of losing Justice Antonin Scalia. Really unfortunate situation, and I give my condolences as well as the whole team here to his family, the Scalia family. But that caused a humongous buzz, actually a disappointing buzz from my opinion. The Republicans and the Democrats both started immediately discussing who was going to be the replacement. The Republicans blocking it, saying, no way, we're not going to put anybody in there. And the Democrats responding, why not? Let's just do it now. Obviously, we all know why it's so important to have a Supreme Court justice, not only to adjudicate the cases that are on their docket right now, but also those social issues that people are trying to persuade one way or another, right? The Democrats want their pro-life, pro-choice issue, or others as well, other social issues, gay marriage, and the Republicans are fighting on the other side for pro-life and anti-gay marriage. So this is a problem if your balance is shifted. Right now it's 4-4 with a guy in the middle, right? 4 liberals, 4 Democrats on the court. Now you -1. Now we're left with 3 conservative judges and 4 liberal judges. And of course, the definitions are broad and hard to define. Nonetheless, the Republicans are afraid we don't want 5-3 with a guy in the middle. They want to keep it 4-4. But here's an interesting question I have to ask you. Could President Obama nominate himself to be a Supreme Court justice? Well, you're going to find out the answer to that question and much more with our interview here, our special report with Professor of Law at Cornell University, Michael Dorf. Take a listen. Welcome, everyone. It's a special report. We're going to be discussing today what happens now to the Supreme Court after that terrible passing of Justice Antonin Scalia. Well, with me today is Michael Dorf. He is a Robert F. Stevens Professor of Law at Cornell University Law School. So let's welcome Professor Dorf. How are you, sir?
I'm well, thank you. Glad to be here.
Me too, but thank you so much for doing this. Unfortunate circumstances, we have to have this interview. But let's talk a little bit about Scalia. What happened here? What's going to happen now with the courts?
So this is a vacancy. There are, by statute, 9 justices on the Supreme Court. When there is a vacancy, the Constitution authorizes the President to nominate and then the Senate to advise and consent. With respect to that, the President also has an option to make a so-called recess appointment, which would last until the next recess of the Senate. But President Obama has ruled that out on the ground that there is sufficient time to go through the regular process. And as I'm sure everybody knows by now, most of the Senate Republicans to have weighed in on this say that they are not going to confirm anybody that the president nominates and maybe not even hold hearings. So for the moment, we have a standoff, and we will see how the politics plays out, especially with the interaction with the presidential election campaign.
Yeah, it's actually tragedy. I was disappointed in the Republicans and how they handled it. I thought they jumped the gun. It was like less than 2 hours after finding out that he passed away, and they were already jumping into this mode.
Well, I think everybody immediately thought about that, and the question was simply whether people had the good taste to wait a few moments before talking about what would come next. And the answer is that politics has its own timetable, so at least some of them didn't.
So that's a great point. That's a great way of looking at it. Yeah, I just pictured myself as being either his son or his wife and thinking, wow, okay, interesting. Now, Scalia, we know Obama's going to nominate. He's already said that. Now, the Senate, they probably are not going to vote yes. They might hold a hearing, and the hearings can take a while, correct?
Sure. Usually they have some period of time that they vet the nominee before the hearing. The hearing itself is often only a couple of days, typically in a debate within the Judiciary Committee and a debate on the Senate floor. The longer period of delay, typically after the nomination, is during the time when the Senate is gathering information and some might say ammunition regarding the nominee.
Okay. And let's look at a little bit of history here. Can we function off of 8 judges?
Oh, sure. First of all, the Constitution doesn't fix the number of Supreme Court justices. In the very first days of the country, the Supreme Court had 6 justices, which is a little bit jarring, both because it's a smaller number, but more interestingly, because it's an even number. And so 3-3 ties were possible. You didn't get many of them because in those days the court tended to have unanimous opinions. It's been 9 justices since roughly the Reconstruction period, but there have been vacancies, and when that happens, the court votes, and occasionally you get a 4-4 tie. When you get a 4-4 tie, one of 2 things happens. Either the case is then sent back, and it's as if the Supreme Court never acted. The official term is the judgment is affirmed by an equally divided court. So that means whatever the previous court said stands, but it doesn't set any national precedent. Or sometimes, if they split 4-4, they won't announce that. They'll just set the case for re-argument. But you only do that if you expect to have 9 justices the next time, because otherwise you're just going to get the same result.
Interesting. Let me ask you this question. I know right now, I think we'd have 4 conservative, 4 liberal, and then kind of the swing man in the middle there. Has it ever been more lopsided? When's the last time it was more lopsided? In other words, being 5 or 6 liberals or 5 or 6 conservatives on the judge court on the court.
Well, these aren't really precise terms. So even today, there are people who would contest the characterization of the 4 Democratic appointees as liberal. I think that certainly Justice Breyer is a moderate on a number of issues. If you look at business cases, the court is almost unanimously conservative in the sense of pro-business by historical measures. But during the Warren court period, that is the Chief Justiceship of Earl Warren, the court was more reliably and consistently liberal. Basically, since the Burger court under Warren Burger, the court has been pretty evenly divided. I would say more often than not having a bare conservative majority, but always with 1 or 2 justices who could be picked off in a liberal direction depending on the issue, because the legal issues don't always divide evenly on a liberal-conservative ideological spectrum.
Interesting, very fascinating. And in your opinion, have you ever seen it where it makes such an impact, especially in a presidential election?
Well, the last time you had something like this, I think you'd have to go back to the election of 1968, because Earl Warren announced his retirement before the election, and then President Johnson wanted to elevate Abe Fortas to Warren's seat. There then ensued a scandal because Fortas had engaged in some improprieties, and what ended up happening was instead of Johnson, a Democrat, being able to fill Warren's seat and the vacated seat by Fortas, both of those seats ended up being filled by Republican President Richard Nixon after the election. And of course, the part of the Nixon campaign was a campaign against the Warren court, which was portrayed as soft on crime and too favorable to civil rights on issues of race. So I think that's the last time it was as clear an issue with respect to particular seats.
I know we have about 4 or 5 minutes left, and we truly appreciate your time. One of the questions I wanted to know, here's a rumor. We'll tackle the rumor first. Is it possible? I've heard rumors of Obama becoming a Supreme Court justice maybe in the near future. Is that a possibility?
So, sure. There's nothing in the Constitution to prevent a former president from serving on the Supreme Court. William Howard Taft was president and
That's right.
Then Chief Justice. The intriguing possibility would be, what if Obama were to nominate himself? Right? Everybody talks about, well, suppose the Republicans block this, and you wait until his successor. And if the theory would be, it would have to be, either Hillary Clinton or Bernie Sanders who would appoint him to the court. So that's the sort of the easy path. The more interesting question to my mind is, could he nominate himself? And that may sound like a ridiculous idea, except if you think about John Marshall, who was the third Chief Justice and certainly the most famous Chief Justice in the early Republic, the person who consolidated power in the Supreme Court in Marbury against Madison and McCulloch against Maryland and other cases, he was nominated to the court and was already Chief Justice, had been confirmed, at the time that he was still acting as Secretary of State in the departing Adams administration. So there is some precedent for being simultaneously in the executive branch and getting confirmed to the Supreme Court. It's not a precedent that I think anyone's going to rely on, least of all President Obama, but that is out there.
That's a very intriguing idea. So obviously, if he nominates himself, he'd have to wait till his presidential term is over.
Yes, you'd think so. Although, as I said, the confirmation of Marshall took place before he gave up his position as Secretary of State. Now, being Secretary of State isn't exactly the same thing as being president, but the Constitution has an incompatibility clause that says you can't be a member of Congress and also hold office under the United States. You can't be in Congress and in the executive or the judiciary. But it doesn't have a clause saying you can't be in the judiciary and the executive. I think most people, including me, think that would be a terrible idea and inconsistent with the basic principle of separation of powers, but it doesn't violate any express provision of the Constitution.
That's a fascinating one, Professor. Never would have thought about that. Now, the last question, we have a couple minutes to go. What are some of the criteria that typically determines who gets chosen as a Supreme Court judge?
So I think presidents of both parties look for people who are learned in the law. That's not an express criterion, except for Solicitor General, but not for justice. But they want someone who's generally a smart lawyer. Both parties would look for someone who is has the right sort of judicial temperament, meaning they're not too fast to judgment. Not everybody who's ever served in the Supreme Court has had an ideal judicial temperament, but that's something you want. Sometimes you look for certain identity characteristics, for lack of a better term. Could be race, sex, ethnicity.
Oh, really?
Geography used to be an important characteristic. You wanted, either a Southerner, a Northerner, or a Westerner, or something like that.
Huh.
And then, of course, you look for someone who has a judicial philosophy, an approach to deciding cases that is more or less in line with your own. For Democrats, that has tended to be along the lines of what, for lack of a better term, the living Constitution. Republicans, at least in recent years, have tended to look for what they sometimes call originalists or textualists. I think those terms are not very helpful, but I do think that presidents of both parties in nominating and senators in deciding whether to confirm look to the person's values and track record, if they're a judge or in some other context, to try to make a decision about whether this is the sort of person who's going to construe the law and the Constitution in a way that's generally in line with their own values.
Fascinating stuff. A lot of criteria there. Lots of criteria.
It's a balancing act.
Yeah, needless to say. Professor Dorff, thank you so much for this opportunity. We really appreciate it.
My pleasure.
So Professor Dorff, everybody, Robert S. Stevens, Professor of Law at Cornell University, giving us insight on the Scalia case and the Supreme Court justices.